Welcome to the deep dive. Today we're really embarking on a crucial journey. We're going to be diving into the very foundation of global justice itself. We're talking about the bedrock document, the one that empowers the world's highest court for the most serious crimes humanity can commit. Our mission today is a deep dive into the Rome Statute of the International Criminal Court. We're going to try and cut through the dense legal text, not just to understand its provisions, but to truly uncover its core principles, maybe some surprising details, and just grasp the sheer ambition behind this global effort to hold individuals accountable. Think of it as peeling back the layers to see the living blueprint of international justice.
And it's a blueprint that really took shape on July 17th, 1998, with the adoption of the Rome Statute. That's what established the International Criminal Court, the ICC, as a permanent institution. What makes it unique and, so ambitious is its role. It's distinct from national courts. It handles what are termed the most serious crimes of international concern. And crucially, it's designed to step in only when national systems are genuinely unwilling or unable to act. That's a key point right from the start.
Okay, so let's start right there at the beginning.
Yeah.
Where is this court actually located, and what's its relationship with, the powerhouse that is the United Nations?
Right. So the court's home is in The Hague, in the Netherlands, a city, pretty much synonymous with international law. What's important to understand is that it isn't just an agreement. It has its own independent legal standing, its own international legal personality. It can act as an entity in international law. Its connection to the UN is through a specific cooperation agreement. But here's the really defining characteristic, something the statute makes clear from, Article 1. The ICC is complementary to national criminal jurisdictions.
Complementary, okay. So it doesn't just sweep in and take over everything.
Exactly.
It's a court of last resort, basically.
Yeah.
How does that work in practice, though? I mean, if a national court is clearly dragging its feet or maybe just making a show of prosecuting but isn't genuinely trying to hold someone accountable, how does the ICC figure that out? Is that a highly contentious area?
Oh, absolutely. It's definitely a contentious area, and it's where a lot of the tension lies, between national sovereignty and international justice. The principle means the ICC will only step in if a state is genuinely unwilling or unable to investigate or prosecute. Unwillingness, that could mean proceedings are maybe designed to shield someone, or there's unjustified delay, or the proceedings just aren't independent or impartial. And inability, that often refers to a total or substantial collapse of the national judicial system, like they simply can't secure the accused or the evidence needed. So yes, determining that threshold is often a complex and highly scrutinized part of the court's work. It's not about proving guilt at that stage. Not at all. It's about proving a state's genuine inability or unwillingness to act itself.
Right, right. That's a critical distinction. Now,
Right.
let's get into the heart of what the court actually deals with. I mean, it's one thing to have a court, but the real test of its mission lies in defining what exactly constitutes these most serious crimes. What are the legal lines drawn?
Well, the statute identifies 4 core categories, and each one is meticulously defined, really aiming for legal precision. First, you have the crime of genocide. What's truly striking about this definition isn't just the horrendous acts themselves, killing, causing serious harm, deliberately inflicting life conditions calculated for destruction, things like that. But it's the absolute necessity of proving specific intent. The intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such a group. That element of specific intent, the dolus specialis, makes it incredibly difficult to prove in court. You're prosecuting not just an act, but a deeply held prejudice aimed at group destruction.
Wow, that intent requirement sounds like a huge hurdle.
It is. Then second, you have crimes against humanity. Now, these are acts like murder, extermination, enslavement, deportation, imprisonment, torture, various forms of sexual violence. But crucially, they must be committed as part of a widespread or systematic attack directed against any civilian population. And importantly, with knowledge of that attack. So it's not just an isolated, terrible act. It's about a pattern, maybe a policy, or a large-scale operation targeting civilians. For instance, extermination isn't just direct killing. The statute clarifies it can also be the deliberate creation of conditions, like, say, withholding food or medicine, designed to bring about the destruction of part of a population. And it's interesting, the statute actually defines gender quite specifically for its purposes here in Article 7, referring to the 2 sexes, male and female, within the societal context. That kind of precision is crucial for legal clarity in these really sensitive areas, tries to leave no room for ambiguity.
That distinction, the widespread or systematic nature, seems key. It separates it from, say, just individual acts of violence, however horrific. What about war crimes? That's a term we hear a lot, more frequently. How does the ICC specifically define them?
Okay, third are war crimes. These are serious violations of the laws and customs applicable in armed conflict. Think of them as the fundamental rules for how warfare should be conducted, often drawn from things like the Geneva Conventions. The statute lists, well, a lot of them, and it makes a distinction between international armed conflicts and non-international ones, so internal conflicts. For example, things like intentionally attacking civilians or civilian objects, and that explicitly means homes, schools, hospitals, that's a war crime. Or attacking undefended towns, also killing combatants who have surrendered, employing poison or poisoned weapons, or even bullets designed to expand or flatten easily in the body. Using starvation of civilians as a method of warfare is explicitly forbidden.
Using starvation as a weapon, that's specifically listed.
Yes. And it also covers horrific acts like conscripting or enlisting children under the age of 15 into armed forces, or using them to participate actively in hostilities. Outrages upon personal dignity, particularly humiliating and degrading treatment. Using civilians to shield military operations. The list is extensive. For non-international armed conflicts, civil wars, basically similar principles apply. Things like violence to life and person, murder, mutilation, cruel treatment, torture. Also, outrages upon personal dignity, taking of hostages, passing sentences without due process by a regularly constituted court. But it's important, the statute deliberately excludes internal disturbances and tensions, such as riots, isolated and sporadic acts of violence. It emphasizes these are about armed conflicts, not just general civil unrest.
Okay, that makes sense. And the fourth one?
And finally, the fourth pillar, added later through amendment, is the crime of aggression. This one's a bit different. It refers to the planning, preparation, initiation, or execution of an act of aggression. But crucially, it applies to a person in a position to effectively control or direct the political or military action of a state. And the act of aggression itself has to constitute a manifest violation of the Charter of the United Nations. Examples of acts of aggression given include things like invasion, military occupation, annexation by force, bombardment, naval blockade, attack by land, sea, or air forces on another state, or even sending armed groups or mercenaries to carry out acts of comparable gravity. What's really striking here is that it targets the leadership, those at the very top who initiate unlawful wars. It's about the decision to go to war illegally, not necessarily every soldier involved in the fighting.
That's an incredibly comprehensive, almost overwhelming overview of the crimes. But, the real test of this whole framework, isn't it, is how it translates into actual justice. How does the ICC actually get jurisdiction, get hold of a case, and when can it truly step in, given all these complexities like complementarity?
Exactly. That's a practical side. First, there's a time limit, what we call jurisdiction ratione temporis. The court's reach is generally limited to crimes committed after the statute came into force July 1st, 2002, or after a specific state became a party to the statute if that was later. It's not retroactive justice.
Right, no retroactive justice.
Then, for the court to actually step in, there are preconditions. Generally, either the crime happened on the territory of a state party,
Okay.
or a state that isn't a party but accepts the court's jurisdiction just for that specific situation, an ad hoc declaration. Or the accused person is a national of a state party. Or again, a state accepting jurisdiction ad hoc.
So territory or nationality are the main hooks.
Those are the main hooks, yes. And as for how a case actually lands before the court, Article 13 lays out three main paths. First, a state party can refer a situation occurring anywhere, really, to the prosecutor, saying, "We think crimes under the statute may have been committed here, please investigate." Second, the UN Security Council, acting under its Chapter 7 powers relating to international peace and security, can refer a situation to the prosecutor. This is significant because it can cover situations in states that aren't parties to the statute.
So the Security Council route bypasses the need for the state itself to be a member or consent.
Precisely. That's a powerful tool, though obviously subject to the politics of the Security Council itself. And third, the prosecutor can initiate an investigation on their own initiative. This is called proprio motu.
Proprio motu.
Yes, based on information they've received about alleged crimes. So they don't need a state or the UN to tell them to start looking. They can act independently if they have credible information.
So the prosecutor essentially has the power to open an investigation, even without a state or the UN pushing for it. That seems like a really powerful independent check within the system.
It is. It's a very important feature for the prosecutor's independence. But, and this is crucial, this all loops back to that complementarity principle we talked about earlier, doesn't it?
Right, it always comes back to that.
It absolutely does. Even if one of those three paths is triggered state referral, Security Council, or proprio motu, The case still has to pass the admissibility test laid out in Article 17, and this really reinforces complementarity. The ICC, fundamentally, won't take a case if a state that has jurisdiction over it is genuinely investigating or prosecuting the same person for basically the same conduct. The court only steps in if that state is proven to be either unwilling or genuinely unable to carry out those proceedings properly. It's designed, really, as a safety net, not as the primary place for these prosecutions.
Okay, so we've seen the powerful legal framework the statute establishes for these crimes and the ways a case can get to the court. But how is the actual machinery of justice built? How is it structured to tackle such immense challenges? Let's maybe pull back the curtain a bit and explore the ICC's structure and the core principles guiding its every move.
Sure. Structurally, the court is organized into several key organs outlined in Article 34. You have the presidency, which handles administration and external relations. You have the judicial divisions, the appeals division, the trial division, and the pretrial division, each handling different stages. Then you have the office of the prosecutor, which we've touched on. And finally, the registry, which handles the non-judicial administrative side, like victim and witness support, detention, and so on.
And the judges themselves, who are they? How do they get there?
There are 18 judges, and they're elected by the Assembly of States Parties for 9-year terms, non-renewable generally. The qualifications are high. They must be persons of high moral character, impartiality, and integrity. And they need competence in either criminal law and procedure or relevant areas of international law, like international humanitarian law or human rights law. Crucially, the election process aims for balanced representation. It seeks representation of the principal legal systems of the world, equitable geographical distribution, and a fair representation of female and male judges. There's also consideration for expertise on specific issues, like violence against women or children.
That focus on diverse representation seems vital for its legitimacy.
It absolutely is. And then there's the Office of the Prosecutor, the OTP. As we mentioned, it acts independently. Its job is to receive referrals and information, examine them. This initial examination is called preliminary examination, and then conduct investigations and prosecutions. The prosecutor and the deputy prosecutors are also elected by the Assembly of States Parties, again for a 9-year term, and they cannot seek re-election. And importantly, Article 42 stresses they cannot seek or act on instructions from any external source. Their independence is paramount.
That independence is so vital, isn't it? Especially when dealing with potentially high-profile figures or politically charged situations. How does the statute try to guarantee that these judges and prosecutors can truly remain impartial, free from, external pressures or internal biases?
Well, the statute stresses that independence throughout. It prohibits judges and the prosecutor from engaging in any activity that might interfere with their judicial or prosecutorial functions or affect confidence in their impartiality. There are also clear mechanisms in place, Articles 41 and 42, for excusing or disqualifying judges and prosecutors if their impartiality might reasonably be doubted. For instance, if they'd previously been involved in the case in a different capacity before joining the court. And all key officials, judges, the prosecutor, the registrar, have to make a public, solemn undertaking in open court to exercise their functions impartially and conscientiously. It's a formal commitment.
A solemn undertaking. That's quite something.
And underpinning all of this operational structure are some fundamental general principles of criminal law laid out in Part 3 of the statute. These are really bedrock legal concepts. For instance, Nolum crimen sine lege, Article 22. Basically, no crime without law. Conduct doesn't constitute a crime under the statute unless it was already defined as such at the time it took place. You can't create a crime after the fact. And legal definitions must be strictly construed, no analogy.
Oh, yeah, no retroactive crimes. Makes sense.
Similarly, nulla poena sine lege, Article 23, no punishment without law. A person convicted can only be punished according to the penalties outlined in the statute itself. And Article 24 explicitly states non-retroactivity ratione personae. No one can be held criminally responsible under the statute for conduct that occurred before the statute entered into force for the relevant state.
Right, setting those clear boundaries in time.
Exactly. Then there's Article 25 on individual criminal responsibility. This is fundamental to the ICC. It makes clear that the court prosecutes individuals, not states or groups. And it defines how an individual can be responsible by directly committing the crime, ordering or soliciting it, aiding or abetting it, or contributing to a group crime with a common purpose. For genocide, it also includes direct and public incitement. And for the crime of aggression, remember, it specifically targets those persons effectively controlling or directing a state's political or military action.
So individuals not abstract entities. That's key.
Absolutely. And linked to that is Article 27, which is huge. Irrelevance of official capacity. This directly tackles the issue of immunity. It states clearly that the statute applies equally to all persons without distinction based on official capacity. So whether someone is a head of state, a member of government or parliament, an elected representative, or a government official.
Doesn't matter.
It doesn't matter. Their official position provides no immunity before the ICC. Any immunities or special procedural rules they might have under national or international law shall not bar the court from exercising its jurisdiction over them.
Wow, that's a direct challenge to traditional notions of sovereign immunity. That's a game changer for international justice, isn't it? The idea that a leader can't just hide behind their title.
It really is. It's one of the most significant aspects of the statute. And building on that individual responsibility is Article 28, the responsibility of commanders and other superiors. This holds military commanders, or people effectively acting as such, responsible for crimes committed by forces under their effective command and control if they either knew or should have known, based on the circumstances, that their forces were committing or about to commit such crimes.
And they failed to stop it.
And they failed to take all necessary and reasonable measures within their power to prevent or repress the crimes, or they failed to submit the matter to the competent authorities for investigation and prosecution. It imposes a duty of vigilance and action on leadership. A similar principle applies to civilian superiors regarding subordinates under their authority.
So, I didn't know isn't necessarily enough if you should have known.
Precisely. Negligence can be enough in certain command situations. Another crucial principle, Article 29. Non-applicability of statute of limitations. The crimes within the court's jurisdiction, genocide, crimes against humanity, war crimes, aggression, do not expire. There's no time limit on seeking justice for them.
No hiding just by waiting it out.
Exactly. And then Article 30 deals with the mental element, the mens rea. Generally, unless the definition of the crime specifies otherwise, a person is criminally responsible only if they commit the crime with intent and knowledge. Intent means wanting to engage in the conduct or cause the consequence. Knowledge means awareness that a circumstance exists or a consequence will occur in the ordinary course of events. It sets a high bar for proving this state of mind.
Intent and knowledge. That seems fair. What about the just following orders defense? How does the statute handle that?
Yes, superior orders, covered in Article 33. The general rule is that the fact that a crime was committed pursuant to an order from a government or a superior, whether military or civilian, does not relieve a person of criminal responsibility. There's a very narrow exception, but it requires 3 conditions to be met simultaneously. The person was under a legal obligation to obey the orders, the person did not know that the order was unlawful, and the order was not manifestly unlawful.
Manifestly unlawful. What does that mean?
It means unlawful to any reasonable person. And critically, the statute provides a non-negotiable clarification. Quote, orders to commit genocide or crimes against humanity are manifestly unlawful. Always. Full stop. You can never use the superior orders defense for genocide or crimes against humanity.
Wow. Okay. That concept of manifestly unlawful orders really drives home the individual responsibility, the need for moral judgment, even within a chain of command. So, okay, when a case actually moves forward through the ICC system, what does that process look like for an individual who's accused? What rights do they have? And how does the court protect everyone involved, not just the accused, but victims and witnesses too?
Right. Let's look at the journey through the court process. During the investigation phase, which is Part 5 of the statute, the prosecutor is responsible for establishing the truth. They collect and examine evidence fairly. They question persons being investigated, victims, witnesses. They seek cooperation from states. And Article 54 specifically requires the prosecutor to take into account the interests and personal circumstances of victims and witnesses, including their age, gender as defined back in Article 7, for crimes against humanity and health, and to take appropriate measures, especially in cases of sexual violence, gender-based violence, or violence against children.
So victim considerations are built in from the start.
Yes. And crucially, Article 55 lays out the rights of persons during an investigation. Anyone being questioned has fundamental rights. They cannot be compelled to incriminate themselves or confess guilt. They must not be subjected to any form of coercion, duress, or torture. They have the right, if questioned in a language they don't understand, to have a competent interpreter provided free of charge. They must not be subject to arbitrary arrest or detention. And if there are grounds to believe someone has committed a crime under the statute, if they become a formal suspect, additional rights kick in before questioning. They must be informed of this. They have the right to remain silent, and that silence cannot be considered in determining guilt or innocence.
The right to remain silent is key.
Absolutely. They also have the right to legal assistance, either of their own choosing, or if they don't have means, to have legal assistance assigned to them free of charge where the interests of justice require it. And they have the right to be questioned in the presence of their counsel unless they've voluntarily waived that right. The pretrial chamber also plays a role here. Under Articles 57 and 58, it can issue warrants of arrest if there are reasonable grounds to believe the person committed a crime and arrest appears necessary, for example, to ensure they appear at trial or to stop them obstructing the investigation or committing further crimes. It also oversees pretrial detention to ensure it's not unreasonably long.
Okay, so there are safeguards during the investigation. What happens next? Does it go straight to trial?
Not quite. Before a trial can even begin, there's a crucial stage: the confirmation of charges hearing, governed by Article 61. This takes place before the pretrial chamber. The accused person must be present with their lawyer. The prosecutor has to present sufficient evidence to establish substantial grounds to believe that the person committed each of the crimes charged. It's a filter, a critical checkpoint to ensure the case is strong enough to proceed to a full trial. The defense can challenge the evidence and present their own.
So it's a kind of mini trial before the main trial.
In a way, yes. It ensures the charges are properly grounded in evidence before the full resources of a trial are committed. If the charges are confirmed, the case moves to the trial phase, covered in Part 6. Trials, under Article 64, are generally held in public. However, the trial chamber can decide to conduct parts of the trial in closed session for specific reasons, like protecting victims, witnesses, or even the accused, or safeguarding confidential information. This is particularly considered for victims of sexual violence or child witnesses. And throughout the trial, the fundamental presumption of innocence, Article 66, is paramount. Everyone shall be presumed innocent until proved guilty before the court in accordance with the applicable law. And the standard is high: proof beyond reasonable doubt. The onus, the burden of proof, is entirely on the prosecutor.
Beyond reasonable doubt, the highest standard.
Indeed. And Article 67 reinforces the rights of the accused at trial. Things like being informed promptly of the charges, having adequate time and facilities to prepare a defense, being tried without undue delay, the right to be present at the trial, the right to conduct the defense in person or through counsel, also, critically, the right to examine the witnesses against them and to obtain the attendance and examination of witnesses on their behalf under the same conditions. The right not to be compelled to testify or confess guilt. They can also make an unsworn statement if they wish. And importantly, no reversal of the burden of proof is allowed.
That sounds like a robust set of fair trial rights. What about the victims you mentioned earlier? How does the statute ensure their voice is heard and their safety is prioritized during the trial itself?
That's a very important aspect, covered in Article 68, protection of victims and witnesses. The court is mandated to take appropriate measures to protect their safety, physical and psychological well-being, dignity, and privacy. Again, special attention is paid in cases involving sexual or gender violence or children. The court can use things like pseudonyms, closed sessions, or testimony via video link. Importantly, victims can also have their views and concerns presented and considered by the court at stages where their personal interests are affected, provided it's done in a way that doesn't prejudice the rights of the accused or a fair trial. This allows victims a formal participatory role, not just as witnesses, but as participants with recognized interests.
Giving victims a voice in the proceedings, that seems quite progressive for an international court.
It was considered quite groundbreaking at the time. There's also Article 72, dealing with national security information. If a state thinks disclosing information requested by the court would prejudice its national security interests, there's a process for consultation and cooperation to find a solution, like summaries or redactions. But ultimately, if a state fails to comply, the court can make inferences or refer the matter. Once the trial concludes, the trial chamber delivers its judgment. It must be in writing, reasoned, based solely on the evidence presented, and delivered in open court.
And if there's a conviction, what are the potential penalties?
Part 7 deals with penalties. Under Article 77, the main penalty is imprisonment for a specified number of years, up to a maximum of 30 years. Or, in cases of extreme gravity of the crime and the individual circumstances of the convicted person, a term of life imprisonment.
Life imprisonment is possible.
Yes. The court can also order fines and, significantly, forfeiture of proceeds, property, and assets derived directly or indirectly from the crime without prejudice to the rights of genuine third parties. And this connects to Article 79, which establishes a trust fund for victims. This fund is set up for the benefit of victims of crimes within the court's jurisdiction and for the families of such victims. The court can order that fines and forfeited assets be transferred to this trust fund.
So there's a direct mechanism intended to benefit the victims financially from the outcomes of the cases.
Exactly. It aims to provide some measure of reparative justice alongside the punitive aspect.
That's a lot to consider about the judicial process itself. It really emphasizes individual rights and victim participation.
Mhm.
But what happens after a verdict? And how does the court ensure its decisions, like arrest warrants or sentences, are actually implemented around the world? Especially when dealing with, potentially powerful individuals or uncooperative states. I imagine cooperation is absolutely key here.
Cooperation isn't just key, it's S. It's the absolute lifeblood of the court. Without it, the ICC simply cannot function effectively. Part 9 of the statute is entirely dedicated to international cooperation and judicial assistance. Article 86 lays down the general obligation. States parties shall, in accordance with the provisions of this statute, cooperate fully with the court in its investigation and prosecution of crimes within the jurisdiction of the court. It's a treaty obligation.
Cooperate fully. That sounds clear, but what does it entail in practice?
It covers a lot. One major area is the arrest and surrender of persons to the court, governed by Article 89. States parties are legally obliged to comply with the court's requests for arrest and surrender. They have to follow their national procedures, but the obligation under the statute is clear. There's an important safeguard here called the rule of speciality in Article 101. Generally, a person surrendered to the court can only be prosecuted, punished, or detained for the crime for which they were originally surrendered. The court needs the consent of the surrendering state to proceed on other charges that occurred before the surrender, unless the person has had a chance to leave the court's custody.
Okay, so you can't just add unrelated charges later without consent. Prevents a kind of fishing expedition, I suppose.
Exactly. Beyond surrender, Article 93 lists many other forms of cooperation. States parties must provide assistance like identifying and locating persons or items, taking evidence, including testimony under oath, questioning people, serving documents, facilitating the voluntary appearance of witnesses or experts before the court. Also, temporary transfer of prisoners to give testimony, carrying out searches and seizures, providing records and documents, protecting victims and witnesses, identifying, tracing, and freezing or seizing proceeds of crime. It's a very broad range of required assistance.
That's a huge list. But what if a state says providing certain information would harm its national security? Is that a loophole?
Well, Article 93 acknowledges that states can raise grounds for refusal under their national law for requests not involving arrest and surrender, but only if the request concerns information related to national security defense. Even then, Article 97 requires the state and the court to cooperate to find a solution. Article 72, which we touched on earlier regarding trial evidence, also applies here. If a state feels a request for assistance under Part 9 would compromise its national security, it has to notify the court and engage in consultations. They must take all reasonable steps to resolve the matter cooperatively, perhaps through modification or conditions. If the state ultimately refuses, the court can potentially make findings or refer the non-compliance, depending on the circumstances. It's not a complete get-out clause, but it is a point of potential friction.
I can see that. And what happens if, say, the ICC wants someone surrendered, but another country also wants them extradited for a different crime? Who gets priority?
Competing requests. That's covered in Article 90. If a state receives a request for surrender from the ICC and also an extradition request from another state for the same person, the state party has to give priority to the ICC's request if the court has determined the case is admissible and the competing request is for the same conduct. If the extradition request is for a different conduct, the state party generally prioritizes the ICC request if the person is sought for one of the grave crimes under the statute, unless the state has a stronger existing international obligation to extradite elsewhere. It gets complicated, but the statute tries to give the ICC priority in its core cases.
That international cooperation really does sound like the biggest practical challenge for the ICC's effectiveness, especially given that not all countries are states parties. Does the statute provide mechanisms to specifically address non-cooperation when it happens?
It does try. The Assembly of States Parties, or ASP, established under Part 11, plays a key role here. It's composed of representatives from all the states parties. Besides electing judges and the prosecutor, approving the budget, and overseeing the court's administration via the presidency and registry, the ASP is mandated by Article 112 to consider any questions relating to non-cooperation and take appropriate measures. If a state party fails to comply with a request for cooperation, preventing the court from exercising its functions, the court can make a finding to that effect and refer the matter to the Assembly of States Parties, or, if the Security Council had referred the situation initially, refer it back to the Security Council. So there are political avenues to address non-cooperation.
So potential political pressure from other states or the UN Security Council.
Exactly. Financing, by the way, under Part 12, comes primarily from assessed contributions from the states' parties based on a UN-style scale. The court can also receive funds from the UN, especially for situations referred by the Security Council, and voluntary contributions from governments, organizations, individuals, etc., provided they meet criteria.
Okay. And finally, a couple of important points. Can states pick and choose which parts of the statute they agree to, like make reservations? And can they leave if they want to?
Good questions. Article 120 is very clear. No reservations may be made to this statute. States have to accept the whole package. You can't opt out of specific crimes or cooperation duties. As for leaving, yes, Article 127 allows a state party to withdraw from the statute. They have to notify the UN Secretary General, and the withdrawal takes effect 1 year after the notification date. However, and this is crucial, withdrawal does not discharge the state from the obligations that arose under the statute while it was a party. This includes financial obligations and, critically, the duty to cooperate with investigations and proceedings that commenced before the withdrawal became effective. It also doesn't affect the court's jurisdiction over crimes committed while the state was a party.
So you can't just withdraw to instantly shut down an ongoing investigation or avoid past obligations.
Precisely. It's not an immediate escape hatch from accountability that was already in motion.
Right, so we've really journeyed through the intricate legal landscape of the International Criminal Court via the Rome Statute. We've explored everything from those meticulously defined crimes it targets, thinking about using starvation as a weapon being explicitly listed, or the precision needed for defining crimes against humanity, to the fundamental rights protecting the accused, the really interesting role for victims, and that absolutely critical, sometimes challenging role of international cooperation. It's a really comprehensive framework, isn't it, designed for the gravest of acts.
It really is. This deep dive, I think, reveals not just dry legal definitions, but the profound ongoing global effort, or at least the ambition, to ensure accountability for the most heinous acts imaginable. Trying to transcend national borders and stripping away that shield of official capacity that might otherwise provide immunity. It's a testament, I think, to the international community's ambition back in 1998 and since to create a system of lasting justice, even acknowledging all its inherent complexities and challenges in practice.
Absolutely. As you've listened, what stands out to you about the Rome Statute? Does that concept of manifestly unlawful orders, the one that demands individual moral courage even in a hierarchy, or perhaps this sheer detail in defining the crime of aggression, maybe change how you view leadership and accountability on the global stage?
Yeah, or consider how principles laid out here, like the non-applicability of a statute of limitations for these specific crimes, fundamentally try to shift the landscape away from impunity. It really does raise an important question to ponder, doesn't it? What impact does a permanent international court, one focused squarely on individual criminal responsibility for these severe crimes, truly have on the pursuit of global justice, and perhaps more importantly, on the prevention of future atrocities, especially given the ongoing challenges of achieving universal state cooperation and enforcement? Something definitely to mull over as you navigate the complexities of our world.